The Criminal Laws Amendment Act of 2018 has introduced a new provision with effect from 21st of April 2018. And this provision excludes the benefit of or takes away the benefit of anticipatory bail to a person who is accused of having committed an offence under these four specified sections. Section 376(3), 376(ab), 376(da), 376(db). 376(3) applies when a person is accused of having committed the rape of a girl under 16 years of age. 376(ab) when he is accused of raping a girl under 12 years of age. 376(da) gang rape of a girl under 16 years of age. 376(db) gang rape of a girl under 12 years of age. So in case of these offences, the benefit of anticipatory bail is not available. What is the effect of this provision? We can sum it up like this. As a result of this new provision inserted by the Criminal Law Amendment Act of 2018, protection of anticipatory bail would henceforth not be available to those persons who are accused of having committed rape and gang rape of women under 16 years of age and under 12 years of age. Then we have one section in the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989, which is a bar against the benefit of Section 438 to certain offenders. This is Section 18 of that Act, and this section provides that Section 438 CrPC shall not be applicable to a person who is accused of having committed an offence under the SCs and STs Prevention of Atrocities Act of 1989. Any person who is accused of any of the offences mentioned in that Act, specified in that Act, will not be granted anticipatory bail. This provision of the Act, Section 18 of the Atrocities Act, was considered by the Supreme Court in a well-known judgment, and the court carved out an exception to the applicability of Section 18 of that Act. This is the exception. The court said that the exclusion of Section 438 applies only when there is a prima facie case of commission of offence under the Atrocities Act. But if it can be shown that the allegations are prima facie motivated and false, then such exclusion will not apply. What is the exclusion being referred to? The exclusion from the benefit of Section 438. The court said that presumption of innocence is a human right. There cannot be presumption of guilt so as to deprive a person of his liberty without an opportunity before an independent forum or court. The judgment under consideration is in the case of Dr. Subhas Kasinath Mahajan versus State of Maharashtra, delivered on March 20, 2018. But soon thereafter, there was an amendment to the SCs and STs Prevention of Atrocities Act in August 2018. Within a few months, Parliament amended this act to nullify the aforesaid judgment of the Supreme Court. A new provision was inserted in that act to the effect that the provisions of Section 438 of the CrPC shall not apply to a case under the Atrocities Act, notwithstanding any judgment or order or direction of any court. So specifically, this judgment of the Supreme Court has been nullified by this new provision in the SCs and STs Prevention of Atrocities Act. The current legal position therefore is that anticipatory bail is not available in case of accusations under the SC and ST Prevention of Atrocities Act. Anticipatory bail provisions are not applicable to those persons who are accused of offences under sections 376(3), 376(AB), 376(DA) and (DB) of the IPC, and these benefits are also not available to persons who are accused of offences under the SCs and STs Prevention of Atrocities Act. We have learnt about the ordinary bail provisions from sections 436 and 437. We have learnt about anticipatory bail provisions from section 438. We will now see what is the difference between an ordinary bail and an anticipatory bail. The distinction between an ordinary order of bail and an order of anticipatory bail is that whereas the former is granted after arrest and therefore means release from the custody of the police, the latter is granted in anticipation of arrest and is therefore effective at the very moment of arrest. Anticipatory bail order is issued in anticipation of arrest before the arrest. If arrest is already made, section 438 has no applicability. Section 438 has a meaning only if arrest is still being anticipated and therefore a person who is armed with an anticipatory bail order will be released at the very moment of arrest if of course he is prepared to give the bail. Unlike a post-arrest order of bail, it is a pre-arrest legal process which directs that if the person in whose favor it is issued is thereafter arrested on the accusation in respect of which the direction is issued, he shall be released on bail. One thing must be noted very carefully, that the order of anticipatory bail is in respect of a particular accusation, and therefore if the arrest is in respect of that accusation only, then this order will direct the arresting authority to release the person concerned on bail immediately. A person seeking anticipatory bail is still a free man. He is not under arrest. He is still a free man and he is entitled to presumption of innocence.